This is Matt Casalo with the RhinestoneWorld.com.
It's Richard Greaves with ScreenMaking.com.
This is Stacy Marshall with Printwear Magazine.
Brian Walker with RTP Apparel.
And you're listening to Two Regular Guys
Podcast.
Podcast.
Hosted by Aaron Montgomery and Terry Combs.
Keep on listening.
All right. Well, welcome to the show. It's Friday, August 31st, 2018. I'm Terry Combs with Equipment Zone, and you can also find me over at terrycombs.com.
And I'm Aaron Montgomery, and you can find me at aaronmontgomery.info. Today, we'll be talking with attorney Gordon Firemark to discuss copyright and trademark law. Very exciting show for us here, Terry. I think this is going to be a good one. We've get asked about this all the time throughout our world, and you kind of go, I don't know, ask an attorney. Well, we're going to do that today. We're going to ask a real live attorney, and so we're super excited to have Gordon with us. He's very knowledgeable on the topic, and also great guy. Has got lots of stuff going on in the podcast world and stuff like that. So if
Fantastic.
You have a Rolodex still, Terry, I don't know if you still have one, but or at least put it in your digital file. You're going to want to have Gordon on.
It's all on my yellow legal pad, man.
Okay. All right. Well, there we go.
Junior yellow legal pad. Hey, I'm really excited to have Gordon on because in my screen printing classes, this subject always comes up, and there's so much misinformation out there in the world about copyright and that sort of thing. So I'm really excited to chat with Gordon today as well. But Aaron, how about any news items?
Yeah, definitely. Let's see here. A couple people checking in already. We got some viewers. Cheryl, Lee Ryan is checking in as well. Good morning. And so cover that. But anyhow, Christine Shreve, excellent. I'm excited already, Terry. So quick news items here, though. I just saw this and I thought this was worth covering. We've talked a little bit about some of the different trade stuff going on and how that affects our world. But the U.S. just announced a trade deal with Mexico, and I saw this on ASI's website, and a special announcement from the Oval Office on Monday, this last Monday. President Donald Trump said he will terminate the NAFTA, North American Free Trade Agreement, and enter into a new trade treaty with Mexico, and the hope is that Canada will join soon. So interesting, lots of different stuff going on there. So it's moving, it's shaking, it's a little bit volatile, but we're trying to bring the information to you as we get it to show what's going on there. So we'll have a link to that full article here in our show notes. Also, I wanted to give a quick shout out to Cindy, who's going to be on our show in early November to talk about holidays and sublimation. But just wanted to share her site because I thought it was a pretty good website with some good information. So heatpresscraftinghints.com, and we'll get a link to that in our show notes as well. What about you, Terry? What news do you got there?
Well, I have an announcement from DAX, a show that you and I participate in quite a bit. The DAX show for 2019, Kansas City, is going to be at the Kansas City Expo Center, which is right by the airport. So people like us love that kind of thing. That's going to be February 22nd, 23rd. DAX, Minnesota is going to be back at Treasure Island Resort. That is going to be April 5th and 6th. And rounding out the year for DAX will be DAX Chicagoland, and again back at Tinley Park Convention Center. That's going to be May 3rd and 4th. And Aaron, I have a few shout outs as well from the MBM show in the Meadowlands, New York City, Secaucus. I can never quite figure out what name to put on that one, but okay. Cheryl Kuchak, who Aaron, as you recall, has been on the show. She's from Just My Imagination Designs. And sorry, Cheryl, that I didn't have much time to talk to you. It was really hectic when she came by, but I appreciated her coming by to say hello. And Justin and Kelly, okay, let me try this. Brunoskovic.
All right.
You guys, I think I did it right. I'm not sure. But Justin Kelly from K&J Graphics in Massachusetts. And Aaron, Justin is a regular listener to the show. And Kelly says that she gets to hear the recap after every single show. So it was fun talking to those guys a couple of times. And then also Nathan Fowler with Minuteman Press in Stroudsburg, Pennsylvania. I think we shouted out to him when he came by my booth in Atlantic City as well. But wanted to say hello to all those guys and appreciate all of them coming by and talking about how much they enjoy the Two Regular Guys.
Nice. All right. Good stuff, Terry. Well, yeah, definitely. Glad you got to see all those folks. Yeah. Cheryl said thanks. She's tuning in right now.
Oh, very good.
Terry, I'm not sure if how's it looks on your end, or if anybody's seen this, but to me, your video is stuck. So if anybody else sees that, we may need to have Terry refresh here. Yep. So Gordon's saying it's stuck too.
Okay,
So
I will
Terry,
do that.
you do a quick refresh. We've got a ton of great questions already coming in on the chat, so we want to get into this. So Terry, while you refresh, I'm going to get us to our commercial here, and then we'll go from there. So we do want to thank everybody that for listening or viewing. If you're checking out the live version here today, we're pleased to bring you this weekly show since February 2013. So this is our 6th season, and we always try to avoid rants, lecturing, or selling. And we'd love for you to visit our webpage at tworegularguys.com and check out all the show notes from previous podcasts with lots of great links and additional information. We also are always looking for suggestions for for future shows. This show today actually came as a suggestion from several of our listeners. So, we listen and we try to do our best to make it happen. And so, again, just contact us through our website, tworegularguys.com. And or you can find us on social media at the number 2 Regular Guys, pretty much everywhere. So if you are checking this via live Facebook, we'd love to hear your comments. Like I said, we've already got some great questions coming in, so we're going to try to get to those. If you are viewing this, sometimes Facebook does kind of only show us the questions that are coming through when you're directly on our page, not through some shared groups or other places like that. So make sure you're at facebook.com/tworegularguys. And again, we're going to try to get to everything we can get to here. And then we're going to also give you contacts for where you can reach out to Gordon later. So just bear with us here. We have a limited amount of time, and I know this is a hot topic. So all right, let's quickly hear a word from our sponsor, the Specialty Graphics Imaging Association, about their upcoming expo. And then we'll hopefully have Terry back on the other side and get Gordon and get this thing started.
Hi, this is SGI's Dan Marks, inviting you to attend the SGI Expo in Las Vegas this October. We're going to show you what's on the horizon, with more than 500 exhibitors showing the latest in dye sub, screen, embroidery, DTG, and more. We have 72 educational sessions, including a garment decoration track, and a special luncheon just for garment decorators. Registration is free through September 19th. Learn more at sgia.org/expo2rg.
All right. Well, thank you very much for SGA's support of our show. Definitely get over to sga.org/expo2rg. And let me see if I can grab Terry back here first and see if he pops in there. Internet. Oh, he's still a blank screen right now. So working on him. Okay. Well, you know what? We don't really need Terry anyways. He's just another regular guy. What we really need is our guest, the guy we're all here to listen to this morning. So we're going to grab him while Terry efforts to be on there. Gordon, welcome in.
Hi, thanks for having me, Aaron.
All right.
Terry's just a figment of everybody's imagination. Anyway.
That's right. He's, just the other side. He's a ghost almost. So, well, let me introduce you here, Gordon, real quick before we get too far into all these questions. Like I said, they're coming in hot and heavy. So hopefully you're ready to rock and roll here today. But Gordon Firemark is an entertainment, media, and business lawyer who helps creatives, business owners, and entrepreneurs to bridge the gap between art and commerce, structuring their businesses, and making deals that make good sense. He's the host of the Entertainment Law Update podcast, author of the podcast blog and New Media Producers Legal Survivor Guide, and the developer of 3 online training programs for theater producers, law podcasters, and digital entrepreneurs at home near Los Angeles, California. He too is a regular guy, putting his family first. He has a superhero of a wife, 3 beautiful children, 3 cats, a dog, and a mortgage, and probably some white picket fence in there too. So, Gordon, thank you so much for joining us here today. Like I said, this has been a hot topic in our world, our decorating world, and we were so excited to find you. Maybe start us off with a little more background about you. I on your website, I loved your story about the last name. So maybe start there. Just tell us a little bit more about you and how you got to this point here.
Okay, well, since you mentioned the story about my last name, Firemark it's a very unusual name. In fact, I am the only adult male with the last name Firemark in the whole world.
Wow.
it's one of those names where in the, I guess it was the late 1800s, early 1900s, if you were coming into America and they couldn't pronounce your name at the immigration center, you know, Ellis Island and those kind of immigration centers, if they couldn't pronounce it on the third try, you got a new name. They just needed to move you through. So that's what we think happened with my great-great-grandfather. Came over from the old country in northeastern Europe somewhere. And, you know, the family tree only goes back that far because it's a new name. So, but we joke that, you know, hey, it's American Indian.
Okay. Awesome. Oh, he is here. He lives. Terry, welcome.
I'm sorry, gentlemen.
Hi,
George.
We had tech problems on my end also. It's just, it's one of those days, you know, but
It's the waning days of summer, I guess.
So,
All right.
so yeah, I was just self-introducing a little bit more. And, you know, I have been working as a lawyer for the last 26 years or so. Before that, I actually got my start in entertainment industry and media very young. I was in kindergarten when I was first introduced to theater, and I was hooked from that point on. And so I got working as a sound and lighting guy in theater, and then worked professionally in that field in high school, and then studied radio, TV, and film in college. And it was only at my senior year in college when the idea of becoming a lawyer ever even came to my mind. It was a professor who suggested it, and I laughed it off at the time. But then a couple of years later, I was working in television, and the Writers Guild went on strike, and that meant everybody was out of work for a while. So I thought, well, that's not a stable career. I'm going to go to law school. So
one of your professors in radio and TV said, "Hey, you'd make a great lawyer." What?
Yeah, there was a professor who crossed over into the from the production side into the policy and management and government regulation kinds of classes, and she picked up on an aptitude that I guess was there. And so, you know, it's kind of cool. I can sort of bridge the gap between the creative side and the business side of things, and because I have some perspective on both. And actually, a lot of us who do entertainment law and media law have that experience. We come from the media side first, and then the law thing rears its ugly head, and off we go. So.
Very good. Well, Gordon, we've gotten tons of questions from our listeners, so let's jump in, and let's start with when is a free design not free?
Well, you know, I almost think that there's no such thing as, well, I agree. There's no such thing as a free lunch. You know, there's always some kind of a price you pay, whether it's, you know, just giving somebody the exposure by using their design and giving them some credit or something like that. Now, if you find something that's genuinely free, that is that it's, you know, the copyright is old enough to have expired, and so it's in the public domain, or it's just such a generic kind of a design, you know, like a cross or a skull and crossbones or something like that. Although even that, you know, can be protected under copyright. So I don't know if there's really such a thing as genuine, truly free, but when there's a license agreement, or if it's in the, you know, Creative Commons licensing, which we can talk about a little bit, or, you know, if the creator of the thing, of the design, has said, hey, go ahead and use this, don't pay me anything, don't give me any credit, nothing, that's when it's really free. Other than that, there's usually going to be some kind of an obligation exchanged, you know, for the use of the design or the work, and we have to be mindful about what those obligations might be.
You know, it's interesting. I teach a lot of screen printing and direct to garment classes, and as I mentioned at the top of the show before I went dark, you know, we get tons of questions, and the most bizarre statement I've heard from someone is, well, I spoke to an attorney, and anything on the internet I can use. And I'm like, that can't be true. No attorney told you that.
Well, either they spoke to no attorney at all, or they spoke to an attorney who's completely ignorant of these kinds of issues. You know, someone who does DUI defense cases might not understand these aspects of the law. But even so, you'd think that that just sounds like terrible legal advice.
Yeah, well, I think people
on the internet and find somebody created that, unless it was created more than 100 years ago, it's a safe bet somebody owns it.
I think people hear what they want to hear. It was probably more like nothing on the internet is free.
All right. Well, Gordon, sharing designs and logos. What if I buy a design on the internet? How do I know if I can use it and if it's been stolen from somewhere else?
That's a really tough question, and I've dealt with some situations around this. You know, somebody goes and buys it in good faith, and then finds out that in fact the designer who sold it to them either stole it or well, that's usually how it happens, or whatever. Or the other thing that happens with that situation is the seller isn't really selling you what you think you're buying. You know, the license agreement or the rights that you're purchasing aren't comprehensive enough. So, for example, if you go to, like a photo, what you call stock photo site, and you buy one of their images, they may be licensing it to you for one-time use for blog posts only. And if you want to put it on a t-shirt, you got a different problem. So you really have to read things carefully and understand the terms of the agreement, the contract that you're making, and make no bones about it. When you buy something on the internet, you are making a contract, and you need to understand what those terms are. It's not enough just to click through. We all just click those little boxes, but if you don't read it, you can get yourself into some hot water.
One of the questions that came up was, can I? There's a local junior sports team logo. Can I use that, or do I need to get permission to use that as well?
You do need to get permission. I mean, sometimes those junior level sports team logos are actually the same as a major league logo. And so you may use it thinking, well, I'm just promoting my kid's soccer team. But in fact, you're also, capitalizing on the national franchise from, Pittsburgh or something like that. And they're not going to be happy about it if you're selling merchandise with their logo on it. So you got to be careful. Best scenario is just, check with the league that you're in and find out. They will have a policy on these things. And, it's one thing if you're making t-shirts just for the 15 or 20 kids on the team or something like that. They probably will be able to let you do that, but you have to ask. You have to get the permission. Don't just assume.
That's good. Yeah, I mean, I think that's kind of just the common sense there. Let's stop assuming everything and just get out and get the permission, and it'll make your life a whole lot easier down the road.
Well,
so,
as one of the gurus I like to follow says, common sense and common practice are rarely the same thing.
Yes, very good quote there. All right. So, Gordon, talk to us a little bit about where does decorating for private purposes stop being private and become commercial from a legal standpoint, the samples, etc.
Well, I'm sort of the mind that there's a fallacy in this question, and that private suggests maybe you're doing something just to put up on the wall in your house, or something like that. Nobody except for a handful of people who ever enter your house are going to see this thing. That's genuinely sort of private. And if I want to make a print of or a wall art hanging of some design that I find out on the internet or whatever, that's probably okay. But as soon as you put it on a t-shirt where people are going to go out in public wearing that, even though it's just your kid or your family, it stopped being private the moment they set foot out into the public arena. And so I would say that's where the line is drawn. When members of the public have access to see this. Now, that isn't necessarily commercial, and that's a distinction worth making. Is you can have a non-commercial public use of something. Technically, in the world of copyright law, that is still a copyright infringement. Whether anybody's going to give you a hard time about it, because chasing after these things costs time, resources, and money. The owner's probably not going to give you too hard a time about it, but it's always possible. There's plenty of stories out there about usually Disney characters being the subject matter in question.
yeah. There's a lot of questions in the comments about Disney and kind of some of their stuff. So we're going to get to that in just a little bit. But kind of just real quick back on that same question a little bit, Gordon. So, like, for example, at our trade shows, we see a lot of people decorating samples to show how their equipment and stuff works. But they're using, the logo of the local sports team and whatever show they're in and things like that, and so everybody's like, oh, well, it's just a sample. I'm not selling it, so it's legal. That doesn't sound like that's actually the case.
In fact, I would say it's even more commercial of a use than if you were just selling one t-shirt with the local team's logo on it, because what you're doing is actually using it to promote your business. That's advertising. And, how is it really different than if you put that in a television commercial or an ad in the newspaper?
Yeah.
You're using someone else's thing in a commercial way to drive business to your company and not paying the creator of that thing. You're using there. It's a raw material that you're not buying. You can't make t-shirts if you don't go buy raw, blank t-shirts. So same thing with the artwork that you're putting on things.
I hear a lot of those folks at trade shows saying, well, no money has exchanged hands, but what you're saying it's just a matter of public, not money has nothing to do with it.
There is nothing in the law that says that in order for an infringement to occur, money has to change hands. In fact, quite the contrary. What the law says is if you make a copy, that's infringement.
Awesome.
If you don't have permission.
Okay.
All right. All of our trade show friends are now scrambling to redo their artwork for the next show.
Well, now let's just unpack that a little bit, because there is still the fact that you got to get caught. I mean, I'm not advocating doing this stuff anyway, but if it only matters if you get caught and they bother to do something about it. So most of the time people are flying under the radar, and that's the only reason they've never heard about this stuff before, is nobody's challenged them.
Gotcha. Well, speaking of flying under the radar, here's another question that came up to us. Etsy, it seems like everything on there is trademarked. It's Disney, pro sports, college teams, and they're operating with impunity every day. It's like the internet's the Wild West. So what is and what isn't being enforced out there?
Well, there's a couple of different elements to this. A lot of it is that flying under the radar, just not getting caught or not being a big enough fish to be pursued. After all, it does take time, energy, and resources to do these things. And let's face it, if a company like a Disney or a Warner Brothers, one of these people decided to go after every single infringer, they would have an army of lawyers working on this stuff nonstop, 24/7. Because there's so much of it, until at some point they put everybody down and people get the picture that you shouldn't do this. The fact of it is that's not how they want to expend their resources. So they'll use the bigger ones, and they'll make a big example of them. And Etsy, by the way, is operating, the website itself is operating under something called a safe harbor. When we run a website or something like that under the Digital Millennium Copyright Act, if one of our users posts something that's infringing, as long as we have a policy that says when the owner of the work in question gives us the proper notice, we'll take it down immediately and then sort of let the parties work it out. As long as we do that, the website operator is immune from any lawsuits in this safe harbor. So that's a powerful tool. Now, it's a game of whack-a-mole when you're an owner of material. You're going to knock one down and another one pops up over here, and vice versa. So and that's another way that these companies have to expend resources to chase after this stuff. The fact of it is they do need to do that if they want to protect their brands. So they do make examples of the bigger fish. But the other side of this is that not all of the uses that you see of something on Etsy are actually an infringement of a trademark or something. If you have a quote or something like that. Now I'm thinking, artwork designs tend to be pretty clearly copyrighted, but there might be a quote or a phrase or something like that that is registered as a trademark to a company, and associated with a particular kind of goods or services. But when it's put up on Etsy on a t-shirt, it's not in the same class of goods or services, so it's not infringing. It's not going to be confused. Let's face it, you have a double mint t-shirt. Nobody's thinking this is coming from the Wrigley Chewing Gum Company. And so there could be, that's a bad example because double mint's a pretty strong mark, but that we can have that circumstance where the brand is associated with one kind of product and it's being used in another way altogether. And also Etsy isn't always a product, right? A lot of people Etsy always is. I'm thinking of Pinterest, but with Etsy, they usually are selling something. So I think it's selective enforcement is really what's going on.
Yeah.
Well,
okay.
Well, help us understand also, I create a piece of artwork. I own that artwork and it's on a t-shirt and somebody copies it. Or I create a piece of artwork and it's on a t-shirt, but I've got the little circle C on it. Or I create a piece of artwork, it's got the circle C, and I send a copy of that artwork to copyright.gov.
Yeah.
what's the ownership, and what's the protection you have on each three of those scenarios?
Okay. Same protection is in place for all of it. So here are the basics of things. Copyright is a bundle of property rights, the right to copy and make distribution of those copies and display and perform and make derivatives from the thing that you've created. As long as you create something original and you fix it in some tangible form, write it down on paper, paint it on a canvas, design it in a computer, whatever, you own a copyright the moment you create that work. There's no requirement that you register it. There's no requirement that you put that C in a circle, the symbol on it. And there's no requirement that that you send anything into the government or anything like that. You own the copyright the moment you create it. So anybody who then copies that work, makes something that is substantially similar to what you've created, they're infringing your copyright. Now, so that's the basics. And what that permits you to do is if you have registered the work, then you can go to court and sue. So a lot of people wait until there's an infringement and then they go register the thing. Because let's face it, you're going to pay $35 to $55 or $60 for every registration you file. So it's a good idea to do that registration early on, because if you do it within 3 months of the first publication of the work, you can get your attorney's fees from the other side, and you can get statutory damages. You don't have to prove the actual losses that you sustain. So, but then, you can go and sue and get a court to issue a restraining order, an injunction against the distribution of the stuff, and collect some money if you can either prove it or you get those statutory damages.
Okay, I'm going to jump off the outline again real quick. So would you put something to bed for us forever? Because I hear this all the time. If there's a graphic and you change it by 25%, then you're free to use it. Would you please tell the world that's not true?
So the question, right. So the question or the test is, are the two works substantially similar? This is assuming that the infringer has, or the alleged infringer has seen the original work, has had access to the original work. Look, if I take an image of Superman and I make his cape yellow instead of red, that might be 20% of the image, depending on how it's drawn, but it's still an infringement because it's still Superman. Nobody's going to be concluding that it's not substantially similar. So yeah, so there's no percentage, there's no rule of thumb about this kind of thing. There are some situations where you're making a change, you're transforming the work in a way that the public policy supports as being a valid exercise of free speech, and that's this defense that you hear thrown about a lot called fair use. If you meet the four factors and it balances out in your favor, then it might not be deemed infringing. But the percentage thing, no, you just changing it a little bit doesn't render it not infringement.
Okay. All right, good. Well, CJ had asked that question too, Terry. So like you said, it's something we hear all the time in our world. Well, I changed it 25% or whatever. I think I may have even said something like that at one point. So I'm glad to finally have somebody that knows.
The terminology that I hear to refute that is if it's an attempt to deceive, or in other words, inferring that it's like Dallas on a t-shirt, just the word Dallas, but it's in the Dallas Cowboys colors. That would be an attempt to imply that this is a licensed product.
Yeah. What we're doing, we're blending two different principles, copyrights and trademarks. So copyright is the design of the thing, the substantial similarity test. And if it's a copy, it's a copy, it's a copy, even if you've made some changes. It's what we call a derivative work, right? It's based on that original. On the other side of this is the trademark aspect, where if you use the distinctive colors or typeface or something like that of a particular city or logo or whatever, then you're infringing that, because it's likely to be confused as being either coming from or being endorsed by the owner of that brand, that trademark. So there's a classic case of a guy was making t-shirts that said cocaine on the shirt, a red shirt with white lettering, cocaine, with the swoosh and the very distinctive Coca-Cola font. And Coca-Cola said, no, you're infringing our trademark. You're confusing the public about the source and origin of this stuff, or the endorsement of this thing, and they put a stop to that. So if you adopt something that is confusingly similar to a particular logo or brand, you make a box of crackers and you put a red triangle in the upper left corner of the packaging, even if it doesn't say Nabisco in it, people are going to think it's a Nabisco product, right?
Yeah. Wow. All right. This is Terry. I hope you're making great notes over there, because we're getting some gems here. Hey, you know what? We're recording this, so this is even better.
Wait, we're recording?
Yeah, hold on. we didn't have that agreement in place beforehand, so
No disclaimer, right?
yeah. All right. Well, hey, everybody that's tuning in, great questions coming in. We're going to try to, like I said, get to all of them. We think we're covering a lot of them, so we might get to a point here at the end, Gordon, where we kind of say, okay, what questions did we miss? And then we'll try to get some of these things back, because I'm wading through about 60 comments right now, and I'm going, okay, did we cover that? Did we not cover that? Blah, blah, blah. So anyhow, but I got a question from somebody that said, how come Disney can use stories that are in the public domain for centuries and transform them and the characters into copyrighted material?
It's a great question, and it's worth discussing, because what public domain means is that the story itself, the underlying sequence of events that's portrayed in the story, is in the public domain. That's why they're allowed to do it. They can take it and use it, and so can you. But don't use anything that is original in the Disney telling of the story or the Disney drawing of the characters. So if you want to create a story about Snow White and the Seven Dwarfs, that's a Grimm's fairy tale that was written well over 100 years ago. You can do your version of Snow White and the Seven Dwarfs. But if the dwarves are drawn or portrayed as looking like the dwarves in the Disney movie, now you're infringing on those designs that were created by Disney employees within the last 100 years. So that's where the new work, the new stuff is or the new original stuff is what's entitled to the protection. But nothing to stop you from telling Robin Hood story. There's a new film coming out on the Robin Hood story. Recent cases have basically looked at Sherlock Holmes, and that's an interesting one, because some of the Sherlock Holmes stories were written recently enough to be protected, while some of the earliest stories are in the public domain. And so, does that mean I can go write a Sherlock Holmes novel? Yes, I can, as long as I don't use anything that came from one of those newer stories. So the expiration of things is a moving target, and it's something to be mindful about.
I'm taking from this that in the original Grimms there was no Sneezy and no Dopey. Is that?
I think that's right. I've never read the original.
well, how about this one?
Hey, Terry, hold on one second. I do
Sure,
want to just kind of get this follow-up question that's posted up there. I don't know if you can see it, Gordon. It says, but Disney goes after any princesses that is a princess, basically.
Well, I'm not sure I agree with that statement. What Disney does, first of all, Disney has sort of appropriated and created the Western version or view of what a princess is and looks like. And so most of the other sort of iconic depictions of princesses are derivative of things that were drawn by Disney's artists in the early part of the 1930s and 40s, So yeah, so that's sort of, but if you want to draw a princess, as long as, let's remember also the way Disney draws the human form is sort of distinctive and unique also. If you want to draw a different version of a princess, there's no reason you can't. That's
all right. Well, thanks for that follow-up. Go ahead, Terry. I jumped in front of you there.
Well, I want to talk along the lines of Disney again and a few others. I know I hear this question a lot, and I don't really have a good answer for it. What about fonts like the Disney font or the Star Trek font or the Star Wars font? Can somebody use those for their own logo, their own designs? I mean, when you see that Disney script name, it says Disney to you, no matter what it says.
Yeah. Well, that's the Coca-Cola story, isn't it? If the font is original when it's let's face it, some fonts are very old. The Times font is old enough now; it's been around for a couple hundred years. That if you want to, you want to create a version of the Times typeface, you're free to do that, or you're free to use the Times typeface in certain way. But again, the what's the word, the typography that the New York Times, for example, uses for its masthead is a distinctive look. And so if I wanted to call it the new Pork Times, let's say I'm doing a newspaper for the bovine industry, right? Or the porcine industry, sorry. I would probably have a problem from them there. But so anyway, to answer the question, a font can be an original design, right? There's an example of it, the New York Times logo or the Coca-Cola script that is used. And so, yeah, they do have a right to claim ownership of those things. Now, that's, again, this is sort of crossing the line between the copyright and the trademark. The designer of the font can own a copyright in the font design. So if I use a copyrighted font in my advertising materials, and the owner of that design of the font, the copyright, recognizes that I didn't purchase a license to use it, I can have a problem, even if I'm not confusingly similar to some other logo out there. So there's two different aspects, both of which can come into play.
Okay. All right. Well, we've got some stuff. Again, the comments keep coming in. They're great. We've got some great questions. So we're going to keep you around as long as we can here, Gordon. But we promise we won't keep you here all day. When your water runs out, we'll be good to go. All right. So the next question is, when a designer and the customer are working together on an art project, who owns the art? The designer, the customer, the company paying the design? We had some comments earlier. Let's see if I can find that one where, let's see, back. I'm going too far, but basically saying that like an embroidery design might have 3 actual owners and some things like that. So can you give us any insight into that?
So yeah, absolutely. This is a great question. I'm really glad it got asked because it's one of these common misunderstandings about things. And Nadia, Nada, sorry, is saying that about the 3 owners.
Yeah.
The basic rule is that when there's not an employment relationship, let me start with the employment. If there's an employment relationship, the employer, and by that I mean, a bona fide employee who's on a salary or an hourly rate, who is paid through payroll and works at the business and at the place of business and those kinds of things. Traditional employee. Employer owns their output as long as it's within the course and scope of their employment to be creating this kind of stuff. If you're not an employee, the independent contractor owns the output, owns the results and proceeds of their work, unless there's a written contract that says this stuff is a work made for hire, or unless they transfer ownership by what's called an assignment of copyright. So if I am, and this is true of all kinds of artistic, when you go hire a photographer to do your wedding, the photographer owns the copyrights in the images. And there are only a few categories of kinds of works where this work made for hire contract can actually operate. So there's some question. So the bottom line is that the designer will probably be the owner of the copyright in the images, and the embroiderer, the person who designs the embroidery, I guess it would be the pattern and the sequence of which stitches happen where and when, that person is making a derivative work. So that's an infringement of copyright unless that person has permission. Now, in most of these instances, that permission is sort of implied and we don't look too hard at that. And yeah, theoretically, that embroidery designer owns the specifics of that embroidery design, but not in the underlying picture that's being adapted to embroidery.
Gotcha.
So if you are hiring somebody to design a logo or a website or just a graphic depiction of something, you want to make sure that your contract is very clear that you will own the resulting material. Otherwise, the designer will end up owning it and could later come along and say, well, you hired me to do that because you wanted to create a print ad, but now you're using it on t-shirts and on a vehicle wrap or something like that. You need to pay me again.
Yeah.
And that does happen. So you want to make sure that all possible intended uses are covered by the contract. Even if you don't end up owning the copyright, you have to have the license to use that design across all the different things you might ever want to do, and for as long as you might want to do it, and so on. So that's where having a written contract is really, really important. Make sure that you that everybody knows exactly what the intention and scope of the agreement is.
Well, Gordon, along those lines, how do we go about getting a design or a saying even that goes along with our brand? How do we go about getting that copyrighted?
Well, so copyright, as I said earlier, is you get a copyright by merely creating the work, and as long as it's original and it's down in some tangible form, you own the copyright. So no hoops to jump through. Good idea to put the copyright notice, the C in a circle, and the year and the name of the owner somewhere on or near it, and it's a good idea to register that copyright for the reasons I mentioned earlier. But when it's a slogan or a symbol that you're using to identify your business, right? The red triangle, the Nike swoosh, the word double mint or something like that, you can also register the trademark, and that is, again, you get some of the rights from just using the thing in commerce and in public. So excuse me, excuse me, just by being out there in the marketplace with this brand attached to your goods and services, you will become identified in the minds of the public as the owner of that brand, but only specifically for particular goods and services. It's a good idea to register the trademark, which is more complicated. Registering a copyright is easy. You can go online to copyright.gov, and it's a badly designed website, but you can navigate through the electronic copyright office form and get
a government website.
I know, right? You would think people who run government bureaucracies would be great designers. But I mean, this is user interface stuff, right? User experience design. And they need to do a remake. Let me just put it there. But
Okay.
The trademark office, actually, the forms are easier to deal with, but it's more complicated legally. And so you can do it yourself. It's uspto.gov, but it's really easy to go down rabbit holes and fall into the traps. And what you get with the trademark office is they come back and they refuse the registration, and then they give you 6 months to respond. That's telling that they give you 6 months to figure out how to respond to them. And then that's where you have to make legal arguments and so on. So my experience is doing it yourself for trademark is not a great idea unless you sort of understand this stuff, and it makes sense to use a lawyer.
And how do you go about finding a trademark lawyer specifically? You don't.
Just call me.
We found one, Terry. We've got one right here. We'll give you his contact information.
That's really
Good enough.
Google trademark attorney in your city. The truth is, you don't need to. This is one of those areas where you don't have to have somebody in your local city to do it. I do trademark registrations for people all over the place and all over the world, actually. And just you want somebody who kind of really gets this stuff, and be also careful about. It's possible to do it with some of these online, do-it-yourself online services. I'm not a huge. Obviously, it's bad for my business when people do that. So I'm going to be candid about that. But I sort of liken it to this: if you were walking down the street and you saw a box at around head height with a hole in the bottom and it just said "haircuts $1," would you stick your head in that box?
$1?
Terry, is that what you did?
You might get a or you might come out missing an ear.
Well, interesting reference on your part and mine. So
right. Well,
Awesome. All right. Terry, did you have any follow-ups there, or do we want to start digging through some of the questions in the comments here?
Yeah, let's dig into some of the questions from our listeners since we're running a little shy on time.
Yeah, absolutely. And a couple of these, we may have kind of covered, Gordon. So I apologize if you're kind of repeating yourself, but I just want to make sure that we get the specifics covered for some folks that have been kind of joining us. We really appreciate that. Okay, so I have a question to add. If I take fabric or a picture that I bought and apply it to something else and enhance it, is that allowable? And I think you kind of covered that a little bit, but maybe just kind of give a quick recap on that.
In the fabrics area, it's a question about whether the designs of fabric are copyrightable, and the some of the recent case law on the subject dealt with some cheerleader uniforms with the chevron patterns and things like that.
Yeah.
And the Supreme Court of the United States basically said, look, if you could take that design off of the clothing and frame it as a picture, then it's copyrightable subject matter, and the owner of that design is the owner of that design. So I hope that answers the question.
Yeah.
But merely taking a particular image from a T-shirt and pasting it into a quilt, patching it into a quilt or something like that, that's probably still infringement of something.
Okay. All right.
Oh, actually, no, I take it back. Because you bought the T-shirt, you're making it's called the first sale doctrine. Once you've bought it, what you do with that article is fine. Now, if you make copies of it and then put it into a quilt, that's where you're infringing.
Okay, so if you take the actual T-shirt, turn that into a quilt,
yeah,
you're good to go. But if you then start making your own copies of that T-shirt, then you're okay. That's great. That's perfect. All right, let's see here. We got another one. I'm also wondering about intellectual property, quotes, designs. How can I tell if I create a design or saying and trademark? If so, no one else can use it, and that goes for other popular quotes. Can I use other ideas, quotes without getting in trouble?
So a quotation isn't necessarily by itself entitled to trademark protection or copyright protection. It depends on sort of how much of a quote it is. So the classic example that I like to cite is the quote, "Use the force, Luke," or just "use the force." That's not copyrightable. It's just too small to be considered, an original work of authorship by itself. But when it becomes distinctively attached to a particular goods or services or a particular brand, when it becomes the brand, then it is entitled to trademark protection. So "Just do it," the Nike quote, or what's the other one?
I know the NCAA owns the big dance for the Final Four.
Yeah, or and three-peat was one that was common when the Lakers won 3 in a row.
Exactly.
National champion, that kind of stuff. Yeah, so those kinds of things can become a trademark when they are they're distinctive and they're associated. So if you come up with a slogan that's distinctive, you can register the slogan, and that's why you can register the title of a podcast or of a TV show or something like that. But it has to be associated with a particular brand in the minds of the public. And by the way, it can be a very generic, non-distinctive phrase that after a while becomes distinctive because people have it has a secondary meaning. I'm thinking of, it's a defunct company now, but Payless Shoes. It's very descriptive, right? That's nothing distinctive about that. But we know that because we walk through the malls all the time, we see Payless Shoes. Now everybody knows, that's a specific company.
Okay.
So it's distinctive.
Yeah, definitely. Okay. Let's see here. We got another one. I see a lot of people saying that they are selling "quote unquote" inspired by designs, which are inspired by Disney or college teams. Is that legal? And I think we've covered this, but maybe just
yeah, I'd have to say it sort of depends. We'd have to look at the individual design in question. If it's just the same color scheme and sort of general style, it's probably okay. But if it's really the same design, just you've taken, Snow White's picture and put her into a different kind of a scenario entirely, then no, I'd say that's still an infringement. So it's going to vary from design to design.
Okay.
You said a phrase. It made me think of, we're not a cover band, we're a tribute band.
Okay. I'm just reading through a couple more to see if there's anything that kind of missed. Legal. Okay. Yeah, we covered that about the changes. I think a lot of the big questions were, how much do you have to change a design to make it legal? And we really kind of covered that really well. So if you missed that, head back and check out those. Okay, I'm going to scroll up to the top here and see if we missed anything.
Some podcasts, some radio shows, some article somewhere came up with that change it by 25% or whatever. And man, did that take on a life of its own?
Yeah. A lot of people would say, that people have weird ideas about what's infringement. If in music, they'll say, well, if you take less than 4 bars or whatever. But the fact of it is, you can have a very distinctive, very original combination of notes that's only 3 or 4 notes. Think of the Beethoven's Fifth Symphony. Bum, 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 bum. Everybody knows immediately that that's a copy if you use that. Now, that one is old enough that it's in the public domain. It's not a problem. But yeah, anytime you hear about a rule of thumb in these areas of copyright and trademark law, be skeptical.
Okay, that's a good point there. Yeah.
Rule of thumb on this is no rule of thumb, right?
Yeah, exactly. Yeah. So I can't find the comment specifically, but I remember reading it earlier. But there was some question about like how long they thought that maybe when you created something you owned it forever. But you mentioned some public domain stuff. You know, is there an actual timeline that this stuff's
Yeah,
good
great
for?
question. So trademarks persist as long as you're continuing to use them in commerce. You know, as long as the brand remains associated with the work. So copyright protection, on the other hand, does expire, and in fact, it's in the Constitution that allows Congress to make a copyright law. It specifically says Congress can do this by creating for limited times protections for works of authorship. And the limited time is designed to basically say, look, we know that art and creativity builds on itself, so we want to be able to do something with it after a while. So the short answer is this: if you created something after January 1st, 1978, which is the date the newest copyright law went into effect, the protection lasts for the life of the author of the work plus 70 years. And if it was a corporate created work or something like that, it's going to be 95 years from the first publication. So there's a little more wrinkles to that. Yeah. So anything after 1978 and the author is still alive, it's definitely going to be protected. If the author is dead, it hasn't been 70 years since 1978. So we're still covered. So if it was created before 1978, then we have a different scheme of copyright, and the protection lasted for 28 years, and then there was a renewal period of 28 years. And if you didn't renew, it fell into the public domain. And then there was an automatic extension that took it out to 75 years and now 95 years. So that's why I say, look, if it's more than 100 years old, it's in the public domain. The operative date seems to be about 1923, 95 years ago. Anything that was created more than 95 years ago is now likely to be in the public domain. If it's created since then, we have this deep analysis to do. Did they register? Did they renew? You know, and what happened in the 60s when there was this extension. So it's kind of crazy.
Yeah, definitely. Okay. Well, lots of myths out there that we're dispelling today. So I love this. Here's another one.
We can't call the show Mythbusters, though.
No, we're not. Never said that. Okay. All right. I was told it was a good idea to print out a copy of what you created and mail it to yourself to prove date of ownership. Is that expand on that for us?
This is called the poor man's copyright, and it's I mean, you know, I guess it doesn't hurt anything. It costs you 45 cents or whatever it is for a postage stamp nowadays. But the fact of it is, a lawyer that I used to work with used to keep a series or a handful of unsealed envelopes that are stamped and have been through the mail. So they're postmarked, but there was nothing in them, and the seal had never been moistened and glued. So you could take one of these envelopes dated 1990 and put today's newspaper in it and seal it up and say to the judge, Your Honor, inside this envelope, when you open it, you'll be surprised to see that I have a copyright in today's newspaper. So I don't think it's really very valuable. I mean, you know, it's a little bit of evidence. It has a little bit of weight, and it might persuade the casual infringer, hey, I've got a sealed envelope with this thing inside it. But you know, if you get into it with lawyers and courts, it's not going to get you very far.
Yeah, definitely. Okay. Another one here, Gordon, and I appreciate you hanging out with us. So we've kind of covered this, but I just want to kind of make sure that everybody got this. What if we buy a Disney fabric and make a quilt with it? Can you sell it without violating copyright? And I think the answer was yes, but maybe explain that for us.
Yeah. So it's that first sale doctrine again. If I buy something that has copyright in it, I'm buying the article and I'm not buying the whole copyright. And what I do with that article is then my business. So if I buy a fabric, presumably Disney licensed the design to the fabric manufacturer and basically saying, yes, you can make and sell this stuff. The fabric manufacturer is selling the fabric with the design or the pattern on it, and you can then, you make whatever you want with it and sell those articles. So you buy a skein of fabric with, or not skein, a bolt of fabric with, I want to say the 7 dwarves on it. You want to make Seven Dwarves pillows? Go for it and sell multiples of it. You bought the fabric, fair and square.
Huh. Okay. All right. Perfect. There we go. So that there's the answer to that. We got tons of questions, so I don't think we're going to be able to get to all of these, but we'll get back in there. We're going to give him.
I've got a little extra time, so we can stick around if you want.
Okay. All right.
It's your show, so.
Appreciate that. Okay. Brett Bowden asked, I want to trademark a slogan. What is the best process? How much would we expect to pay for something like that potentially?
Well, you can stick your head in the haircut box if you want and do it yourself, or do it with a one of those other companies, and they'll charge you a few $100s to do it, plus the cost of the filing fees with the government. The filing fees are for a single trademark in a single class of goods or services, and there's 45 or 50 of these different classes, depending on what you're selling. The cost for the government fee is about $225 to $275, depending on how you do it and whether it's a simple one or a complex one. Figure $250, and then legal fees. If you want to hire a lawyer, we all have different charges. I'll tell you that my fee for a single mark in a single class is $750. So you're looking at $950, $975 to get a registration in a single class. And then if you add multiple classes, of course, then the price goes up.
Okay.
Right. Brett has flowing locks, so I don't think he's going to stick his head in that box. So.
Yes, he's got great hair.
I might get sucked in.
All right. Here's another one. One guideline we use is, will we be selling this because of the work someone else has done in publicizing or creating another design or product? If the answer is yes, we shy away from using the design. I think that's a correct assumption. I think you kind of.
I think it's there's a rule of thumb. I think that's a great approach to it, is saying, look, you have to ask, does somebody else own it? And the way they come to own a brand is by using it and promoting it and building the brand. So I think that is the right approach on the trademark side. On the copyright side, hard to say. Still a good idea, and better than just willy-nilly. And you should be mindful if you're in the t-shirt making business or something. Like I'm thinking of some of these companies that do screen printed t-shirts. Anybody who wants to can post their take their design, upload it, put it on t-shirts, and sell them in a store. I'm thinking like Teespring and
Cafe Press and
Zazzle and those kinds of things.
Zazzle, yep.
Yeah, I mean, they are to a certain extent covered by that not fair use, the safe harbor that I mentioned under the DMCA. If they get notified that somebody posted something or created something that that is owned by someone else, they take it down and they follow that DMCA procedure. So if you're doing things online, the DMCA procedure is something you really want to get acquainted with and understand how to make it work.
Gordon, one of the things that we, our listeners, garment decorators, run into is somebody comes in from State Farm Insurance and they want to have shirts for the summer picnic. They want 100 shirts that say Jim Smith, State Farm Insurance, Ashland, Kentucky, and we want the State Farm Insurance logo on there. Most of us print that, but I assume we're in I assume we're in trademark infringement that's never going to be pursued.
No, I don't think it's even that murky. My sense of it, and again, I haven't looked at the agreement between State Farm and its franchised agency operations, but part of the franchise in that situation, or the whatever the relationship between the individual agent and State Farm, is that you're out selling our product. You can use our logo to help you do that. So there's something in writing somewhere that's going to govern that. Now, whether it extends to T-shirts, or can you put the State Farm logo on the local baseball, the Little League baseball teams jerseys, maybe that's got to be covered there. But my guess is that for the company picnic scenario, or even just let's just make casual Friday shirts with the logo on it, I think the State Farm's never going to have a problem with it, for one thing, and it's probably licensed as part of the franchise arrangement.
Very good.
All right. Yeah. So I think we just covered the question that I've got posted up there on the screen.
Let me address something else there. So should you ask that franchise agreement was the question?
Yes,
I think
correct.
no. I don't think you asked to see it. I think what you ask for is the promise from the customer, the client, that they have the right to do this. So if you have a work order form or a contract that you use when you take on a job for them, or maybe it's just terms of service on your website, they should make the representation and the warranty that they have all the rights necessary to all the material they're presenting for you to print. And then they should also indemnify you against any loss or damage or legal fees that arise if there's a problem.
Nice. Okay.
Get a lawyer
All right.
agreement.
Awesome. All right, Gort, we're going to do one last question from the viewers here. And again, lots of other ones, but we're going to give them your contact information. We're going to try to answer these all together, any ones that we missed. But if I want to create designs with military logos to support our veterans, what are the concerns?
All the same concerns we've talked about here apply to military logos, as I understand it. Now, I am not an expert on this, and I haven't searched into this particular question, and it might merit some research. But I believe that the logos and designs of the branches of the military are protected under trademark law or other federal law that may be sort of similar. And I'm quite sure that the government will have something to say about it if they don't like the way you're using those designs and images. You don't want to create an affiliation or an impression that there's an affiliation or an endorsement. So yeah, I think you need to dig into that and get appropriate licenses if possible, or determine that you don't need those. And yeah, you can get on the internet and do that research, I think, fairly easily.
Okay. Awesome. All right, Gordon. Now, the thing I really want to get in front of people is tell us a little bit about your stuff, where people can find you, your podcast. You got tons of great stuff going on that we're going to put in the show notes. But I definitely want to hear about your YouTube channel and your upcoming webinar, if you don't mind.
Okay, so thank you for that. Yeah, I've got a ton of different stuff. I have products and brands and courses and things like that for anybody and everybody, basically. I think for your audience, my product that it may be of most interest is something I call the Digital Entrepreneur's Business and Legal Toolkit, and it's an online course and forms and stuff like that for folks that are doing business online. And I get into explaining these issues that we've been talking about today in fair detail, and you can check that out. And all of my other stuff is all on a clearinghouse website at gordonfiremark.com. That's GORDONFIREMARK.com. Yeah, my podcast is called Entertainment Law Update, and entertainmentlawupdate.com will get you there, or you can find it in iTunes and Apple and iTunes and Google Play and those kinds of places.
Uh-huh.
Yeah, so the webinar that I mentioned, or that I want to mention, is called, I have to look it up because I just changed the title of it last night. It's 7 Success Strategies for Top Performing Creative Business People. And basically, in my 26 or so years of working with folks in the creative businesses, I've sort of been able to see and discern and distill the traits and characteristics and habits that that the successful ones have adopted and used to get to the top of their game and to sort of stay there and keep the momentum going. And so I'm doing this webinar at firemark.com/success webinar, and it'll be on Thursday, the 13th of September at 5 p.m. Pacific. And yeah, come on over to Success Webinar, firemark.com/success webinar, and register. And I think you'll be impressed and entertained and take some good stuff away from that.
Awesome.
So,
all right. We've got it listed up there on the screen right now. We will post it in the comments. We will post that in our show notes over at tworegularguys.com as well. Gordon, thank you so much. This has been amazing and great information. We've dispelled so many myths here today that now I can actually talk about this without going, man, how bad am I lying to people here?
Well, Terry and Aaron, thank you so much for having me. It's been a lot of fun. I love the sound of my own voice. Who am I kidding? But I like talking about this kind of stuff. So,
you definitely have a passion for it. It's awesome. So we'll get over there. And we did have, okay. Hey, Gordon, what do you happen to have the link again for the toolkit off the top of your head?
The
by
toolkit,
chance?
I don't have a separate link for it. Just
Okay.
head on to gordonfiremark.com and scroll down. You'll see it. It's listed among all my stuff.
Gotcha. Okay. Awesome. Perfect, Gordon. Thank you. Have a wonderful day, and we will talk to you again soon.
Thank you. Have a great day.
Terry, awesome
Wow.
stuff, man. I still reeling here, and again, all of the comments, questions, just everything was fantastic. So those of you that are catching this on the podcast version, you got to get over to facebook.com/2regularguys. Check out all the comments. We'll be continuing this conversation on that thread probably for a long time. So we're gonna get everything. And go talk to Gordon, all those kind of fun things, Terry. I think this is a topic that we could probably bring him back for and go even deeper. So we'll
absolutely, and I was really looking forward to this show, and it lived up to everything that I was looking for, and it's going to help me, just like you mentioned, Darren. It's going to help me answer a lot of questions for folks when these things arise, and I need to especially talk to my trade show friends. About the graphic printing.
No kidding. I'm going to be walking around going, make note. I'm not going to be the copyright police. So anyways.
All right,
Terry. Well, let's get to wrapping this up here, and let's first hear a word from our sponsor, Equipment Zone, and then we'll be back to get 5 things.
Our show today is sponsored by Equipment Zone. Go to equipmentzone.com for the Epson F2000 direct-to-garment printer. Equipment Zone is the only Epson reseller who sends a technician to every customer location for training. This is an absolutely free visit to your location. Equipment Zone is also the manufacturer of #1 pre-treat machine in the industry, the Speed Treater TX. With no compressor and no special tanks, the Speed Treater TX is the easiest and most consistent pre-treat machine available worldwide. Go to equipmentzone.com for the Epson F2000, the Speed Treater TX, and for all your DTG inks and supplies. That's equipmentzone.com. That's equipmentzone.com.
And be sure to get over to the Equipment Zone site to take a look at the DTG Academy. That's a 2-day event happening in Franklin Lakes, New Jersey, New York City area, and also here in Tempe, Arizona, in the Phoenix area as well. So check that out. It's a great event, and there are a limited number of seats, so it will sell out quickly. So check that out. And Aaron, before we do 5 things, do you have any events coming up?
Yeah, definitely have a few things coming up. We had a few comments in there that the link for the toolkit was not working, so we'll get with Gordon and check that out and make sure that we've got that, and we'll get it posted up there in not only the show notes but also on the Facebook page here. So never fear, folks, we will come through for you. All right. Yeah. So tomorrow morning, every Saturday morning, I do Small Business Saturdays, and I am going to be halfway through my 5-part series on writing a business plan, developing a business plan. So tomorrow morning, we're going to talk about the marketing plan section of your business plan. So that happens at 11:30 a.m. Eastern and 8:30 a.m. Pacific time over at my Facebook page, my personal one, facebook.com/aaronmontgomery.info. And then October 17th, I will be presenting at the Essential Small Business Strategies session the day before SGA opens. I will be the keynote, I think. That's what I'm going with. I'm the closer, so I'm telling everybody I'm the most important. But no, there's some amazing,
the headliner.
The headliner. Here we go. There's some amazing people going to be presenting there, so I'm humbled to be part of that group. I'm going to be talking about marketing your business online. And then Friday, October 19th at 10:30 a.m., I will be at SGA presenting digital marketing, growing your business with social media and email marketing. So there we go. And I just had a post here that I had to share before I get to your stuff, Terry. We should get Gordon in contact with some of our trade shows. I think
to be honest, Aaron, I was thinking the same thing. That the room would be filled, and all he'd be able to do is answer questions. No presentation, just throw your questions.
Yeah, nice. And Gordon's still hanging out in the lobby, giving us the thumbs up on that. So good stuff there. Terry, what about you? What do you got coming up here?
September 8th, Aaron, I'm going to be doing an intro to direct-to-garment printing seminar at the ISS show in Orlando, and that's going to be Saturday, 10:30 to 12. I'm going to be doing a free Epson direct-to-garment all-day seminar on September 12th in Indianapolis, and of course, exhibiting with Equipment Zone there September 13th through 15th. DTG Academy here in Tempe, Phoenix, is going to be September 21st and 22nd. A lot of great speakers at that event. Wrap up my September, I'll be doing the free DTG all-day seminar in Fort Worth, Texas on the 26th, followed by exhibiting again with Equipment Zone September 27th through 29th there in Fort Worth. And Aaron, you and I will be doing a live podcast from the ISS booth there, and looking forward to that. And all my upcoming events through 2018 are at terrycombs.com under tour dates. 2018
is almost over, Terry, so you might want to think about updating to 2019. No,
I need to buy a new calendar, because
a new planner.
My new planner, where I can handwrite all my stuff in.
Perfect. Our show producer is going to be teaching at the NNEP Embroidery and Digitizing Conference in Indianapolis, Eric Campbell. So make sure to check that out. That'll be September 13th and 15th. Just head over to nnep.org to check that. I think it's org. All right, Terry. Well, you ready to do some 5 things here?
I am. Aaron, today I want to do 5 things to make peak season overtime endurable. For a lot of folks that are going to be coming into peak season soon. And somebody just mentioned to me the other day, well, after the holidays, I'm like, what, Labor Day? What? Oh, we're already talking about those holidays. So number one, obviously you're going to be paying time and a half or whatever is dictated in your state. Don't be a trickster with people's incomes. So no paying a regular rate under the table. Limit your overtime. Everyone has a breaking point, even for more money. So if overtime is too regular, you're either understaffed or you're under-equipped. Number 3, a 4-day production work week, 10 hours per day, makes a Friday overtime day much easier to sell than after-hours work. So think about your production floor going to a 4 10-hour day. Number 4, a late-night pizza break goes a long way towards the happiness of the troops when they're working overtime. And number 5, make sure every person who came into work overtime is thanks for their extra effort and dedication. So I paid them to come in, so why should I thank them is not the right answer here. And it all comes down to treating your employees like the valuable assets that they are.
Nice. There you go, Terry. Well, those are fantastic. I know over at Pick the Gift, we're getting ready for the big holiday push here. So I will copy and paste those and bring them over to the powers that be there. So, all right, real quick here. Gordon gave us an updated link for his toolkit. So it's firemark.com/toolkit. So go check that out if you were looking for that. But I think that webinar he's going to do is going to be perfect. It is my birthday, so I will that'll be my birthday present to me to go check that out. So.
Very nice.
All right. Well, Terry, I think we've done it. We've gone over time and we've come to the close of another show. So let's wrap this up here.
And I even started early because I thought this was a show that we had to do 30 minutes early. So I've really put some time in today.
Overtime for Terry. I'm not paying you time and a half, buddy. I'm sorry.
All right. We want to thank our show producer, Eric Campbell. And you can find his latest articles at Printware Magazine and also find everything he's doing at ericcampbell.com. That's ERICH, ericcampbell.com. We would also like to thank our sponsors, the Specialty Graphic Imaging Association, SGIA, and Equipment Zone. We appreciate all your support.
Great. I apologize, Terry. I just saw another comment that got me off track here, but I think it really kind of wraps up what you were saying about, so you pay people for their efforts. You thank them because they do it under your roof and not someone else's. So
very well said.
I just had to pop that up there. Had to got me off track, but hey, we're 2 regular guys, so that's what happens. But Terry, joining us again next week, we're going to have Patrick Bardsley with Spectrum Design, who's been on the show before. It's been a few years since we've had Patrick on, but they're doing some great things with a mission that's really near and dear to my heart. They work with autism, and those of you that know me know that I have an older son who has autism, so it's a topic that I'll try not to cry, I guess is what I'm saying, Terry. So, but we're going to talk to Patrick and see what's new over there at Spectrum Designs, including a new thing that they've got going on called Spectrum Suds. And Terry, that is not beer, actually.
Now I'm disappointed.
First too, but, and then let's see here. We can also talk to him about Spectrum Bake and some other fun stuff. So it's going to be a great show next week as well.
All right. Well, very good. This is the end of the show. So, Aaron, until next week, he's Aaron Montgomery. I'm Terry Combs, and we are the Two Regular
Guys. Thank you for listening to Two Regular Guys. Check out our website at tworegularguys.com. That's the number 2, regularguys.com. You can also interact with us over at our Facebook page, facebook.com/tworegularguys, or send us a tweet, twitter.com/tworegularguys. And we have a YouTube page. You can find all that from our website, tworegularguys.com. Thanks for tuning in, and we look forward to spending some time with you again next week.